So friend, remember, don't go with the viral message. The practicality is that we are much under the CPA Act 2019. We are governed by CPA Act 2019. Not only that, the tune of crores of compensation now we have started saying in 2019. Because 2019 Act, based on the various judgments, let me speak and start with one judgment of AMRI, one of the landmark judgment given by Honorable Supreme Court, while defining and deciding about the medical negligence cases. Beautiful judgment, which has demarcated everything which needed to be. And one judgment, which is always a problematic for doctors, because consumer can use this. The judgment is a beautiful judgment. Do read it. Had defined the concept and context of compensation while giving 11 crore plus compensation. They have decided the methodology also. Multiplier method may not be there, but what need to be considered have very clearly demarcated in the judgment. And Honorable Supreme Court has considered mental agony, mental harassment, loss of companionship, legal expenses, incidental expenses, everything while defining and deciding about the compensation. So naturally, today in every judgment, these are going to be followed. People are very intelligent to give a multiplier method also, that if a tall person is earning X amount and died due to medical negligence at the age of 40, and he was supposed to earn up to 60, 20 years with this particular income on IT paper, multiplied this is going to be this much of earning, which normally been used under accidental cases. The judgment also been interpreted by various my colleagues, very clearly said that human life cannot be compensated by any amount of money. So human life become very prior, very important, very beautiful. So naturally, amount and life, there's no relation. So any amount. The same judgment where lady died because of Steven Johnson reaction, where 100 crores was sought by the complainant, 6 crore with interest, 11 crore plus was given, has opened the door of. The same judgment is observed as interpreted by my colleagues. And to reduce the compensation, when the counsel has argued that she was a housewife, not a earner, so there's no question of multiplier method and earning part altogether, it was observed that housewife not only take care of in-laws, but also educate their children and make them a good citizen. Her teaching and her services to the family cannot be said to be inferior than any employee working in any employment. So no question that she is housewife and not earning means less compensation. And this judgment is cited by opponent lawyer in majority of cases, in multiple cases, to opt for good compensation altogether. And they are struggling. We are struggling because judgment is spoken everything in detail, in depth. And on the basis of this judgment, you'll see that new Consumer Protection Act has got a definition of mental agony. They've got definition of mental harassment. They talked about mental injury. Everything was now included under the new CPA. And domain of compensation has gone to extreme high. Based on the same judgment, there was another judgment came where the tribal lady died because of medical negligence. Some NGO was supporting her family because they're very poor. Matter gone to Consumer Fora, matter gone to State Commission, where because she was a tribal lady, non-rural lady, very less compensation was given. But this NGO has gone to Honorable Supreme Court only on the basis of judgment of AMRI. And then the Honorable Supreme Court observed the same, saying that she is a tribal lady and non-earner, cannot be said that her compensation should be less. While giving a higher compensation in that case, Supreme Court, Honorable Supreme Court has observed that human life is a precious and requires more importance, requires more compensation. So now that judgment has become a real obstacle in a compensation domain in a court of law. Why judgment? Why today we are talking about judgment? As I said, the first and very important thing, it bridges the gap where there's no law to fulfill that and make a law. Further, the same judgment work as a precedent in this country. Precedent means as a citation, as a law, which has been used by various advocates in various court of law. And precedent means if any upper court has given some judgment on same ratio, then lower court judges cannot overrule that and give their own findings. So such a judgment has started coming in the country. And that's the reason why it is important for us to understand the judgments altogether. And on the basis of judgment, then definitely Parliament or Assembly comes, overrule that, and come out with the act to protect the affected people. To make you understand, let me share another judgment which is holding today also very, very good. Even after 26 years of judgment as a precedent is a judgment of cross-pathy. The Poonam Verma's case, very, very famous case which got decided in 1995. In 1995, where DHMS doctor has given a treatment to a patient for fever, got admitted to Hinduja hospital and later died. The wife has filed a complaint for the compensation. Since every possible care was taken by the doctor, including the investigation and treatment, he was cleared by all lower courts. But the lady went to Supreme Court. In 1995, the consul has only produced one evidence in front of a court. And that is a Homeopathic Act, CCH Act, which says that the registered doctor with CCH can practice homeopathy only. The word homeopathy only has blocked them, and the law is absolute, friend. 2 into 2, 4. In spite of every possible thing done by the doctor, court has observed, since law does not allow you to do a cross-pathy, it is deficiency in service. And matter gone against the doctor, and cross-pathy practice was banned thereafter. Whole country got impacted when it came to Ayush doctor. And thereafter, after this judgment, lots of agitation done, various other matter gone in court of law. State being a purview holder of health sector for making a law. On Mukhtar Chand judgment of again Honorable Supreme Court, where defined that state has been empowered to make a law. In Maharashtra, if you see, lots of notification was brought to protect Ayush doctor, that is BMS and BUMS doctor. And finally, the MMP Act 1965, Maharashtra Medical Practices Act, got amended in 2014, where Section 25 of the same Act, the two new provision was added. Provision 4 and 5 have protected these doctors. Even Act says that they are allowed to do modern medicine or practice in which they are trained in, including the postgraduate practitioner are allowed to use latest technology, latest knowledge. Based on that, the CCIM very recently brought a notification allowing their general surgeon to practice surgery in various domains. The state law become very powerful. Same Maharashtra state, to protect their doctor, to give them extra benefit on the basis of CCH, gone ahead to regulate the health sector in the country, brought a pharmacology course for homeopathic doctor, DHMS doctor, amended MMC Act, Maharashtra Medical Council Act, by adding another section, allowing this particular doctor to get registered under MMC, Maharashtra Medical Council, after doing pharmacology course, notified. Naturally, other party impacted has approached High Court, and because the matter is in the court of law, till the time it get decided about the notification of Maharashtra state government validity, it's the ultra virus or allowed matter still as it is. But the impact of 1995 was so much that today also cross-pathy practice is challenged in various states of the country. Still, there is a struggle between the doctor when the cross-pathy practice comes in a picture.